Hey there, Legal Tea listeners. This is your host, Jenny Roselle. Today's episode of Legal Tea is a cautionary tale where we talk about real-life cases and real-life clients and real-life facts. They are things me or my office have actually worked on. For today's episode, we're going to be talking about a case where, from the beginning, it was just one thing after the next. And to keep things straight, let's just start all the way at the beginning, when the client first reached out to my office. And let's call that client Nancy. So Nancy called and shared that her sister, Peggy, lives in a nursing home and that Peggy had significant cognitive impairment. And specifically, she suffered from Alzheimer's. Prior to that impairment, Peggy had created a solid estate plan. She had a power of attorney, last will and testament, a revocable living trust, healthcare representative appointment. She had a really solid plan. Now, it's important to note, especially with the topic of this episode, that my office did not do her plan. She was originally from actually a totally different state, and another attorney in that state did her plan. And, it's something I'm constantly blabbing about on here to hashtag do your estate plan. So at least good for her, she got that estate plan done. In those documents, Peggy had designated a friend as her primary power of attorney, her executor, her trustee, etc. And if her friend could not serve, she listed a big national bank that if I shared the name, you would definitely know who it was. Though I'm going to refrain from sharing the name of the bank, mainly because I've seen many banks do what this bank did. So honestly, calling them out individually does not really seem fair because a lot of banks would have done exactly what this bank did. Now, I'm sure you're thinking, what did they do, Jenny? Tell me. We'll get there, I promise. So where did I leave off? Okay, so Peggy had created this estate plan, right? A solid one. And subsequent to its creation, that's when she had got diagnosed with Alzheimer's. Ultimately, that gradually took over, and she ended up in the nursing home, and she just couldn't stay at home anymore. And staying at home was most definitely not in her best interest. So Nancy, Peggy's sister, in the first meeting she has with our office, explained that the friend that Peggy appointed in all Peggy's documents had tragically and unexpectedly passed away somewhat recently. So that meant the bank was next in line to take over, right? Well, Nancy hopped on the phone prior to this meeting, but she hopped on the phone and finally gets connected with who she needs to talk to at this bank. And it was someone at headquarters and, some other, I'm sure, big city. A complete stranger to Nancy and Peggy. Nancy explains to this bank representative the situation, that we've got Peggy's estate plan appointed so-and-so as, all these different roles, power of attorney, executor, and trustee, and that so-and-so passed away. And guess what, bank? You're up. Well, the bank representative begins asking questions. They're asking, who the customer is, the assets involved, the values of the assets, etc. And ultimately, the representative said that they would get back to Nancy soon as to kind of what the next steps were. Nancy thought, okay, great, I'm getting somewhere. A few days pass, which turns into a few weeks, and after arguably too much time has passed, Nancy thought, I never heard back from the bank. I should give them a call. So Nancy tries calling again. Of course, as we know this awful song and dance when you call any big company, Nancy gets a completely different representative on the line. This representative said, "Oh, did they not tell you what the bank's position is on this case?" Nancy said, "No, I haven't received any phone calls or letters or emails or anything." The representative said, "Well, it wouldn't be economically efficient for us to serve because the estate does not have enough assets for us to be in charge. Essentially, what the representative was saying was that it was not worth their time. And do you even want to guess how much Peggy's estate was worth at that time? Over $2 million. And that's not worth their time? Wow, okay. So now what? That's when Nancy enters into my office and enters into our process. Peggy's documents were out of people, right? And the only way to get anyone in charge of anything at this point was a guardianship proceeding. That is, involving the court to get someone appointed to take care of her financial affairs. So not only did we have to lay this bad news on Nancy, but she had also shared with us that bills were going unpaid because no one had access to the accounts as power of attorney or trustee. So like, for example, her nursing home bill, they hadn't gotten paid like in several months, and they were starting to get really grumpy. And I guess rightfully so. Any business would get grumpy about unpaid bills. Like I said, the next step was getting a guardianship over Peggy, and Nancy said she was willing to serve as Peggy's guardian. So we walked through, what a guardianship process looks like, what a guardian even is, what a guardian even does, what they're supposed to do, etc. And then once we get her appointed as guardian, our plan was to submit her Peggy's trust to the court to request that the court appoint Nancy as Peggy's trustee. What a process, right? All of this because the bank wanted to resign from the trustee position, and this poor client, Nancy, was left picking up the pieces. So fast forward a few weeks, we filed our guardianship documents with the court. Court set a hearing. We showed up, got Nancy successfully appointed as Peggy's guardian. We all go home that day. We're feeling good, feeling like, hey, step one is done. Let's celebrate at least temporarily. So now it was time to request the court to get involved with the trust and have the court appoint Nancy also as the trustee of Peggy's trust. So we filed our petition and the court set another hearing. So we go marching back to the court to present this second part, this kind of part 2 request to get Nancy appointed as the trustee. At this hearing, the judge ultimately agreed with our position and approved our request to have Nancy serve as the trustee of the trust. Yahoo! So, yeah, that's worth a celebration, right? So I suppose, because we did get what we wanted, though I'd be remiss if I didn't think about what caused all this extra work for the family. It was solely because the bank did not want to serve as the trustee. They came out and told us it was not, financially or economically efficient for them to serve. And we were left with a trust document that held assets, which are supposed to be used to pay her bills, like her nursing home bill, but no one was in charge of said trust until we got Nancy appointed. So just think about it. Not only did all these bills go unpaid and, of course, accrue interest sort of unnecessarily, but also Nancy, as now the appointed guardian and trustee, had to utilize Peggy's assets to pay us to get them out of this pickle. To be honest, it wasn't cheap either. We had a lot of time in this case. We had several pleadings we prepared. We had court appearances. Naturally, the county in which this case was in was kind of far. We had a ton of communication with the client, the court, the bank. So yeah, there was a lot of work involved, which yielded a hefty fee. Now, you may be thinking, why would Peggy put the bank in this position anyway? Put the bank in the position as power of attorney or executor or trustee. Well, I have two thoughts on this question, and they don't really relate to each other, but I think they're both very important to talk about. So first, believe it or not, most states, you do not have to ask someone to put them in documents like this. Technically, what I'm saying is you don't have to get their permission to list them in a document. Some states in some documents do require the person you're appointing to sign off on knowing they're in your document, but Indiana is not like that. You could list Dr. Seuss in your power of attorney document or in your last will and testament or your trust and Dr. Seuss not know. And I mention this because it's very likely that Peggy did not ask the bank to put them in her documents. She may have just kind of thrown them in there thinking, oh, it'll probably never end up in their hands anyways. Wrong. It did. Her friend, who was in that primary position, had passed away, and the bank was the next in line. So yeah, interesting. You don't have to ask someone to list them in these documents. Or heck, maybe she did ask the bank, but at the time her estate and her assets were higher, and they thought it would be worth their time then. Anyway, on to the second point I want to chat about on, why would Peggy even put the bank in this position? So second, I see documents all the time that list a bank. So this is not an infrequent thing. I think if I had to narrow it down, I see people list banks in this capacity in primarily two instances. The first instance is when clients that are, say, in their 50s and 60s currently, 50s, 60s currently plus, let's call it, who did their basic estate plan when they first had kids. And for whatever reason, it was super common for attorneys to designate, back then, to designate a family member or a friend first, and then they would sort of just plug in a bank as a backup. I see far less families list banks now in these type of rules. But for you Legal Tea listeners that are, call it 50 plus, you're who I'm talking about. It was really common when you were younger and did your first estate plan to designate a bank. So you may want to check your documents. Another instance I see designating a bank is when a client has no one to appoint. And I see this somewhat often nowadays as well. So think about people that, may not have children, or they may not have people that they trust to put in this type of capacity. It's a hefty job, and you better trust these people. Or maybe people just want to take the burden off of their loved ones. I bring this last topic up, especially this last explanation about, putting someone like a bank in these roles even nowadays. And I bring it up to bring awareness to this issue. Am I saying designating a bank is bad? Absolutely not. It has worked just fine for a lot of people for many years. I think what I want you to take away from this episode is, first, if you have existing documents that names a bank, have you checked to make sure that bank even still exists, which is another big problem I see? Or have you checked to make sure they'd actually take your case? And second, if you're considering naming a bank in a document, have you had those conversations with the bank to understand what their policies are, like their thresholds? That way, they don't do, if it ends up in their hands, they don't do what the bank in this cautionary tale episode did to my client. Better yet, even if you do designate a bank, maybe make a provision in your document to say, hey, if everything falls apart and I don't have anyone to serve in XYZ role, then ABC happens. Any solid estate attorney can guide you on coming up with kind of how to structure that and what to do kind of as a backup to a backup plan. Alrighty, shifting to next week, we are back to the current events, current trends topic, where we talk about something I've seen or run across, maybe on the news or social media, that I think would be interesting to talk about on here. During next week's episode, we're going to be talking about someone out of Chicago, Illinois, who passed away. And he had a sizable estate. I think it was like approximately $11 million or so. And the kicker? Well, he didn't have an estate plan, so that whopping estate is going to very distant family. And just wait until you hear the number of distant family members involved. So tune in to that next Tuesday, Legal Tea listeners. Until then, be well and take care.